5 seconds to go. Start. In the case of Rai Sahib Ram Jawaya Kapoor and others versus State of Punjab, a constitution bench of this court observed thus: it may not be possible to frame an exhaustive definition of what executive function means and implies. Ordinarily, the executive power connotes the residue of governmental functions that remain after legislative and judicial functions are taken away. The Indian Constitution has not indeed recognized the doctrine of separation of powers in its absolute rigidity, but the functions of the different parts or branches of the government have been sufficiently differentiated, and consequently it can very well be said that our constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. It could thus be seen that the constitution bench of this court has held that our constitution does not contemplate assumption by one organ or part of the state of functions that essentially belong to another. In the case of Indira Nehru Gandhi versus Raj Narayan and another Supra, reiterating the position that the principle of separation of power is a part of the basic structure, a constitution bench of this court held thus: the political usefulness of the doctrine of separation of powers is now widely recognized, though a satisfactory definition of the three functions is difficult to evolve. But the function of the Parliament is to make laws, not to decide cases. The British Parliament, in its unquestioned supremacy, could enact a legislation for the settlement of a dispute, or it could, with impunity, legislate for the boiling of the Bishop of Rochester's cook. The Indian Parliament will not direct that an accused in a pending case shall stand acquitted or that a suit shall stand decreed. The reason of this restraint is not that the Indian Constitution recognizes any rigid separation of powers. Plainly, it does not. The reason is that the concentration of powers in any one organ may, by upsetting that fine balance between the three organs, destroy the fundamental premises of a democratic government to which we are pledged. The Constitution bench of this court, though, admits that the Indian Constitution does not recognize any rigid separation of powers, yet holds that by upsetting the fine balance between the three organs, the fundamental premises of a democratic government to which we have pledged will be destroyed. The court observed that the Indian Parliament will not direct that an accused in a pending case shall stand acquitted or that a suit shall stand decreed. A nine-judge bench of this court, in the case of I.R. Coelho, dead by L.R.'s versus State of Tamil Nadu, recognized the doctrine of the separation of powers as a system of check and balance. The court observed that the separation of powers leads to prevention of tyranny. The court, while emphasizing on the interconnectedness between judicial review, rule of law, and the separation of power, observed thus: equality, rule of law, judicial review, and separation of powers form parts of the basic structure of the Constitution. Each of these concepts are intimately connected. There can be no rule of law if there is no equality before the law. These would be meaningless if the violation was not subject to the judicial review. All these would be redundant if the legislative, executive, and judicial powers are vested in one organ. Therefore, the duty to decide whether the limits have been transgressed has been placed on the judiciary. Judicial review is justified by combination of the principle of separation of powers, rule of law, the principle of constitutionality, and the reach of judicial review, Democracy Through Law by Lord Steyn, page 131. This court reiterated that equality, rule of law, judicial review, and separation of powers form parts of the basic structure of the Constitution. Each of these concepts are intimately connected. It has been held that there can be no rule of law if there is no equality before the law. It observed that rights would be meaningless if the violation was not subject to the judicial review. The court records the danger of legislative, executive, and judicial powers being vested in one organ and therefore held that the duty to decide whether the limits have been transgressed has been placed on the judiciary. While considering the importance of the doctrine of separation of powers in today's world of positive rights and justifiable social and economic entitlements, this court, in the case of State of UP and others versus Jeet S. Beast and another, observed thus. If we notice the evolution of separation of powers doctrine, traditionally the checks and balances dimension was only associated with governmental excesses and violations. But in today's world of positive rights and justifiable social and economic entitlements, hybrid administrative bodies, private functionaries discharging public functions, we have to perform the oversight function with more urgency and enlarge the field of checks and balances to include governmental inaction. Otherwise, we envisage the country getting transformed into a state of repose. Social engineering as well as institutional engineering, therefore, forms part of this obligation. While expanding the contours of the doctrine of separation of powers, the Constitution bench of this court, in the case of Kalpana Mehta and others versus Union of India and others, observed thus. The concept of constitutional limitation is a facet of the doctrine of separation of powers. At this stage, we may clearly state that there can really be no straitjacket approach in the sphere of separation of powers when issues involve democracy, the essential morality that flows from the Constitution, interest of the citizens in certain spheres like environment, sustenance of social interest, etc., and empowering the populace with the right to information or right to know in matters relating to candidates contesting election. There can be many an example where this court has issued directions to the executive and also formulated guidelines for facilitation and in furtherance of fundamental rights and sometimes for the actualization and fructification of statutory rights. This court therefore observed that this court can issue a direction to the executive and also formulate guidelines for facilitation and in furtherance of fundamental rights and sometimes for the actualization and fructification of statutory rights. The aforesaid decision would lead to a question as to whether, when the adjudicatory functions are entrusted to the judiciary, can the officers of the state government take upon themselves the adjudicatory function and without a person undergoing a trial be inflicted with a punishment of demolition of his properties. In our view, such a situation would be wholly impermissible in our constitutional setup. The executive cannot replace the judiciary in performing its core functions. When we are considering the issue with regard to rule of law and separation of powers, we will also have to take into effect the matters where the executive transgresses its power and acts as a judge and demolishes the structures of the persons without following the procedure prescribed by law. Though the doctrine of public trust has been largely applied by this court in environmental matters, it cannot be disputed that the executive exercises its powers as a trustee of the citizens. Therefore, the executive actions must be consistent with maintaining public trust. Conversely, when the executive acts in breach of the principle of rule of law and separation of powers, the doctrine of public trust and accountability would come into play. Stop.